Good afternoon. Good, Happy New Year, all of the above. Welcome to our series of bar prep classes for the February bar exam. You're all still alive at this point, which is a really good thing to see. As time progresses, you'll look more like zombies than you do today. But I promise you, you will survive. We're, as you can see from the schedule, and everybody has a copy of the schedule, should have been in your packet. We will be meeting approximately once a week. This first week, we actually have 3 scheduled. I apologize for that. We didn't intend to have 3 the very first week, but we needed to switch Professor Kang's Saturday session. It was originally scheduled later, and he asked for an earlier date. So normally it's going to be about once a week. Fridays oftentimes, but we work around the bar schedules, so occasionally we have a Wednesday date. Each session will be approximately 3 hours. Today it's going to be a little less, though. I am aware, that gets you out into rush hour traffic, so we try to get them started on time and finished as quickly as we can. We had a little glitch today with campus just opening today after the holiday. Something seems to have fallen through the cracks with the pizza. So Susie's, if we can't find the guy very quickly, Susie's going to go make a pizza run, so we'll have some pizza for you a little bit later this afternoon. So how do the classes work? Topics vary and presentation style is going to vary. Today we're going to do multiple choice questions and we're actually going to, we'll do with the clickers and interact. The goal here today obviously is not going to be to teach you everything you need to know for the MBE portion of the exam. Can't do that. It's a little early anyway because you haven't studied a lot of topics. But what we're going to try to do today is look at each of the topics and talk about how you think about them. And how to kind of conceptualize the topics and some of the ways that they are likely to test those topics to get you started. Oops, pizza's coming, yay. On Friday, we're going to do the first of the essay sessions. And everybody always wants to know what my predictions are. For the Florida portion, you have to come on Friday to find out what my predictions are. Not telling you today, but I will on Friday. And then Saturday, of course, Professor Kang is going to talk to you about the First Amendment. His session will be very short and always very informational and highly entertaining, as you all know from Professor Kang. Then we're going to move forward the next week. Professor Martin will be presenting on commercial law. That's a session you definitely don't want to miss. Each one, again, is going to be a little different. Professor Kang is just going to lecture to you. My sessions tend to be a little more interactive. I want to make you work a little bit. Professor Martin will also make you work some when you get to her session. In terms of how we're going to proceed, mechanical stuff, probably for many of you the most important part of each class is what's in the fake fishbowl there. We used to have a real fishbowl, but it broke. When we take a break, each time we will do a drawing, and the name that we draw will get one night's hotel room in Tampa. So it's a really good deal. You get only one, right? So if you win this week, you don't get to go back into the pool on Friday. And we restrict it to those of you who are taking the February exam. We may have some people who are taking the July exam who are in here now. I think some of our advanced standing students have asked about coming in, those who will be taking the exam in July. So if you're delaying your exam, then also, we ask you to wait until the July classes to be eligible. The other thing that you might be wondering about, I wish I could give you more information, but I can't, but just to give you a heads up, the released questions, we will be sending you fairly shortly information about the released questions. The gentleman who handles the release of the released questions for the National Conference of Bar Examiners is still on vacation. But we will be getting those out to you very shortly. Other kinds of housekeeping things as they set up the pizza, and then I'm going to let you run out there and grab pizza before we start. I will be available throughout this time period, and I want to beg you, urge you to write essays for me. You're going to be writing essays for your commercial courses, and you can send me, if you like, the same essays that you're sending to your commercial courses. It's really important to get feedback on your essay writing, and I promise you I will give you detailed feedback on your essay writing. And I can also promise you that people who have sent essays for me and have engaged in that part of the process have always done well on the Florida portion of the exam. So it's worth your effort. If you send me, I always use Marta Perez as the example. Marta sent me 17 essays when she took the exam. If you know Marta, you know that's something Marta would have done. Maybe some of you don't know her anymore, but she graduated a couple of years ago. Marta knew she needed to work on her essays. She worked on her essays, and she did really well on the Florida portion. And don't think, well, I'll just study for the MBE. I can get a really good score on MBE, and I don't have to worry about Florida. Bad idea. You want to do well on both parts of the exam, because you never know what will happen. So don't skimp on either part, and especially don't think that all you have to do is practice 5,000 questions and you'll pass the whole exam. There's a lot more that's involved in the process. So send me your essays. If you have questions about studying, you've got me, you've got Amar, and you all know Amar, and you know he's a really valuable resource. He's going to be around and available as well. And we want to encourage you to interact with us as much as possible. No question is too stupid. And if you just want to cry, and at some point, you probably will maybe not even just want to cry, you might want to jump off the roof. Before you jump off the roof, come and talk to us. We're there. We've been through it. We know what you're going through. We've been through it. We took the bar exam, not just yesterday, but still. It doesn't matter how long ago. I don't even want to tell you how long ago I took my first bar exam. Still painful, the memories. It's not a good process. So please, avail yourself of our services if you're just needing to blow off some steam. Now, I'm going to send you out for pizza in a second, but before I do, any kind of general questions anybody wants to ask about either these classes or the bar prep in general? Yes, sir.
For Saturday's lecture, is it only limited to Amendment religion law?
Yes. Yes, Professor Kang is very specific about that, and so that is it. And it's, as I say, it's going to be a fairly short session. It'll be about an hour and a half max, probably. You, I'm sure, can ask him other questions at the end of the session, but he'll be giving you a handout, and it is very specific, and it's a great lecture. And by the way, of course, stuff that can be tested on both parts of the exam. Every so often, part more of what we'll talk about when we get to the essay portion of my classes, the bar examiners, when it comes to Florida con law, veer off into just plain old con law. Of course, when it comes to the First Amendment, we in Florida have the same rules that you have under the federal Constitution. So his lecture will be valuable for you for both parts of the exam. Again, very narrow. Most of the rest of the lectures you're going to get during this time period will be more general. And if you cannot attend a lecture for any reason, they are all obviously being recorded. You can tell your friends, especially if you have friends who are studying far away and it's too far for them to drive. The lectures are recorded. They will go up on my web course. My web course is for Bar Prep, a Lexis web course. So go to Lexis Blackboard and sign up for the web course. All of the materials will be posted there. The lectures eventually, probably by the end of the week, this one will be posted. They all end up, except for Professor Nathanson. He prefers, when we get to the Civ Pro lecture, he prefers to post his lecture his own way. But I will give you, the link so that you can access it. And he's got a ton of stuff on his website. If you haven't visited his website, he'll tell you all about it. He's got all sorts of good stuff that can help you with your bar prep. Okay, other questions? If not, Amar, is the pizza set up? Okay, let's all, or anybody who wants pizza, take a step outside, and then we'll start the lecture.
Okay.
Yeah, please. Yeah, sign in.
I started photography. So far, I'm on top of it and stuff like that. But I have an MBE book that I bought from this year for contract. Somebody told me that the questions have kind of changed a little, so should I still work with that?
Well, be very cautious with it because it's got what's called the old style questions.
Okay.
It's not going to give you the best experience.
Okay. And then I've also heard about Adaptivar.
Yeah, same thing with Adaptivar. Adaptivar has recent questions and it has old questions. So while it can be a great tool, you have to kind of take that into account. And actually, I'll be talking about question style in just a moment, so you'll know what to look for in the questions. Yeah. Yeah, please sign in.
Thank you. I thought it was. Happy New Year, Singer.
Happy New Year to you too.
Not me. Yeah, I guess we just print our names and drop
Just
it in.
name is all we need. Name is all we need. One here?
It's true that has been released a couple of packages for the enemy from
Well-
night minute to night minute.
Well, wait, that's what I was talking about. You're going to get those questions,
Oh, I
access
need
to
to
those.
get all-
You don't have to do anything. We're arranging it. We just don't have all of the information yet. The gentleman who arranges it at the national conference is on vacation. So as soon as he gets back, we'll get the information out to you.
That's a different question for the OP.
Oh, no, it's the OPE.
That's the OP?
It is
So
the
it's
same
gonna be
thing.
The full team.
Yeah, you're going to get all 400.
Okay.
Yeah, yeah.
For the raffle, I noticed that it says for graduates in December 2015.
Yeah.
I graduated August 2015.
It's okay. Yeah, you're okay. Because it is your first time around,
Right,
so yeah.
right, okay.
Yeah,
How do you feel about investing in Adaptivar?
You know what? Several people have asked, so let me address it generally. It can be a great tool. You have to be a little careful because some of the questions are older.
Or what?
Older. And so, let
Old law and stuff?
and old style. And so we're going to talk about style, and then you always have to be careful. They use actual released questions, which is great, but they use some of the older ones.
Right.
And
Which
if the
depart-
if the law changes, yeah,
So then these 400 that we're getting,
those are
they're
new.
gonna be
They're new. Yeah.
So then I
yeah.
think that would be more beneficial.
Yeah, it's the best that you've got in terms of representing what you'll see on the exam, the 400. Yeah, I'll clear that up. Okay, thanks. Thank you very much. Thank you. Thank you very much in the back. Thank you. Let's find our seats. If you haven't gotten your pizza, grab it now. You're, of course, free to head out there and grab it as you need to. I've gotten some good questions while people were grabbing pizza, so I want to answer them generally, and some of it's going to be part of the lecture anyway, some of it not. So question number 1 that came from several people about using additional sources. Now, remember what you're going to get. Compliments of St. Thomas, the 400 OPE, the 400 released questions, most recent released questions from the National Conference of Bar Examiners. They are recent, the law is going to be current, the style is current, that's what's key. And it's important to practice questions that represent what you're going to see on the bar exam, and those 400 questions are the best example. And that's not saying that you're not also getting great questions from your commercial course, just saying again, those are real bar exam questions. Now, several people have asked about Adapt2Bar. It's a nifty little tool, and it can be helpful. You just have to be a little cautious with Adapt2Bar because it includes some older questions. And with older questions, 2 things to always keep a lookout for. Of course, if it's property and it's an old question, who cares, right? Property's ancient. It's not going to change, not very much anyway. But if it's, for example, constitutional law, which is constantly changing, or criminal procedure, which is constantly changing, the law may have changed. And in Adapt2Bar, because they're licensing released questions from the National Conference of Bar Examiners, so they can't change the answer. So you always have to be a little cautious and make sure if you're using Adapt2Bar and you answer a question and you think, wow, but I thought I got it right and it says it's wrong, make sure that it's a question that's dealing with current law. Number 1. Number 2, some of the Adapt2Bar questions may be in the older style, which we'll talk about in a moment. The bar exam, 99% is going to be in this one particular style with a few variations on the theme. And it's important, again, to practice the style of question that you're going to see on the bar exam. So let's talk about that, because that's really today's topic. And I want to encourage you, as we're going along, ask your questions. As I said before, no question is too stupid. And we're going to talk a lot about substance, but we're also going to talk about study technique. So if you have questions, what should I do, what should I not do, please ask, because it's tough. I was talking earlier today to one of our recent grads, and she said, wow, I feel so sorry for the people taking the bar exam right now. You know, and this is somebody who's just been through the process, who's licensed to practice, who's out there practicing right now, because she took the exam before civil procedure was added. And I don't even want to tell you the number of subjects that have been added since I took the Florida bar exam. It's almost doubled. You have the same amount of time to study for the bar exam that I had with half the number of subjects. So it's tough. It is tough, and I'm not going to sugarcoat it. And we all, those of us who've been through it, we know how hard it is for you. But is it doable? Yes, it is. People survive every time. So let's talk about multiple choice on the MBE. MBE only. When we get to Florida review, which we will be doing as we go along, I'm going to have certain sessions where we do some Florida multiple choice questions. The rules that I'm telling you today about how multiple choice questions work are applicable to the MBE portion, but not to Florida. That's all I'm going to say about Florida multiple choice right now. It's its own animal. But these rules are definitely applicable to the MBE portion, and of course that's 200 multiple choice questions, which you will get on Wednesday. Stop for a second. I'm assuming, but we should never assume anything, that at this point you all know what the format of the exam is, right? Tuesday's going to be your Florida day, and Wednesday's your MBE day. On your Florida day, unless they change it, and they could, but they won't, you're going to have 3 essays in the morning and 3 multiple choice component in the afternoon. Again, we'll talk about that more. But your second day, your Wednesday, is going to be 200 multiple choice questions, 100 in the morning, 100 in the afternoon. So what are those questions going to look like? They're going to follow what we call the new MBE style. It's not new anymore, but we still call it new. So let's see if I can get that to work. Maybe not. Let's do it this way. So you're going to start out, and we'll do a sample question in a moment. You're going to start out with a short fact pattern, 500 words or less, and quite frankly, they're oftentimes less than that. The fact patterns are not going to be as long as some of the ones that you may have seen in law school, depending on who your professors were. They're going to be simple, they're going to be to the point, and in these fact patterns, a really important part of understanding how MBE style questions work, no fact is irrelevant. Some of your professors may have included on purpose irrelevant facts in multiple choice, irrelevant facts in essay. It's a legitimate way of testing, because guess what? When a client comes into your office, the client doesn't know what's relevant and what's irrelevant. That's your job to sift through. But for MBE purposes, and as we'll see also for Florida essay purposes, every fact counts. So as you read the question, you've got to stop with every fact and say, why is it here? If you don't know why it's there, you've missed something, because it's going to be there for a reason. So that short fact pattern, and in that fact pattern, no cutesy stuff, and which disappoints me greatly. I used to have so much fun, well, if it's fun, fun anyway, writing multiple choice questions, writing essay questions. I used to theme them. In fact, I was talking to some friends at a funeral recently, they're people that I knew when they were law students, and they remembered all my cute stories. They didn't remember the law, but they remembered my cute stories. Not anymore on the bar exam. They've stripped all that out. It's going to be buyer this, seller that, plaintiff this, plaintiff that, or defendant that. And the stories are going to be very, very basic. So remember that also. Very simple. You got to keep track, but it's not that difficult. Now, following that short fact pattern, you're going to have the lead-in, the call of the question, whatever you want it to call. It tells you what the question is about. And again, in new style MBE questions, it's very, very specific. That's the good news, I think. It's not, what do you think? It's going to be very specific, and you'll see that as we go through the questions. Your job, of course, is to answer the call of the question. I cannot stress that enough, and when we get to the essays starting on Friday, I'm going to be emphasizing that. You will have learned a lot of information. You want to use it all. You can't. You use what is right in front of you. You don't stray. Don't ever try to change the multiple choice questions to suit what you want them to be. And of course, you can't do that with the essays. Now, following that, you're going to have 4 answer choices called options. Some of your law school exams may have had 3, maybe 5. It's always 4. And I want to urge you, and you're going to laugh, and you're going to say, it's not me, but somebody always does it. When you get your Scantron sheet, A, B, C, D, don't pick E. Don't pick F. You get no points for picking E or F. A, B, C, or D. And make sure you bubble something in. Don't know the answer? Well, let's hope you do, but if you don't, bubble something in, because you get a 25% chance of getting the question right if you bubble something in. If you don't bubble something in, you get a 0% chance of getting that question right. And even worse, you run the risk of screwing up your grid. I see people every time coming back and saying, oh, I kind of got lost, and all of a sudden I shifted questions 78 through 98, and it ended up at 79 through 99, So make sure you bubble something in for every single question. Now, how do you attack the question? Most people are going to tell you, and here I differ from some people based on experience of a lot of years. Most people are going to tell you to go to the call of the question first. And for a number of people, that is exactly what you want to do. But some people, myself included, and a lot of people I've worked with, actually do better starting with the fact pattern. So I want you to try both approaches and find the one that works best for you, because it's a very individual thing. What's good about both of the approaches? What's good about going to the call of the question first? Well, it certainly focuses you in, right? And you know where the question's going. It can help you read the facts. But what's not so good about reading the call of the question first? Two things. It slows you down. So if you're a slow reader and you go to the call of the question first, then you got to go back to the fact pattern and then read the call of the question again. You're spending more time. So just be aware of that. And number two, would be dangerous for somebody like me, because I like to read really fast. If you read the call of the question first, you automatically screen the facts. And that can be really dangerous. Every word counts, as I told you before. So you have to be careful not to ignore stuff in the fact pattern after you've read the call of the question. So what's good and what's bad about starting with the facts first? Well, what's maybe bad is you don't know where it's going. And maybe you need that little extra boost to starting with the call first. However, if you do a really good job of reading the facts, you should be able to predict the call of the question. If you can predict the call of the question, you're going to get the right answer, because you have interacted and you know where the question is going. So once again, no right or wrong answer on that particular point. Try them both out, see what works for you. Now, when you get to your options, again, you've got 4, and the typical MBE style question today comes in 2 pairs. 2 yes because and 2 no because. A lot of times the no because comes first and then the yes because. That part doesn't matter. 1 will be right. That's going to be what's called the key, and the other 3 are going to be wrong. They're the distractors. And that's one of the things that we're going to focus on today is how do you know when it's a distractor? Well, in the broad sense, a distractor is anything in which the conclusion, yes or no, doesn't match up to the rationale, which is what follows the because. So your job is to match the conclusion, yes or no, with the correct rationale. And if you do that, that's your key, your correct choice. And what oftentimes happens, particularly if you're going too fast, your gut tells you yes. And so you immediately ignore the 2 no's. But you don't have the right rationale for the yeses. And so no is actually the right answer. So make sure you match the rationale and the conclusion. And never pick the first one that you read. It could be the right answer. A could be right. But you never know when a better answer is following. And if you're rushing, speeding through the questions, then you're going to miss the potential for getting more questions right because you haven't read all 4 choices correctly. And always, again, it takes a little bit of time, but it's time well spent. A is right because, B is wrong because, C is wrong because, D is wrong because. Go through that process, interact. You probably all know by now how important it is to mark the packet up. The more messy your exam packet is, the better job you're doing of reading, and therefore the better job you're doing of answering. One final point, and then I'll take questions before we do the sample question. I always like to say speed kills when it comes to multiple choice. And most of you are thinking, oh my God, 1.8 minutes per question, hit it, move on. Don't go too fast. You have to know what the proper speed is for you. Some of you will be like, I read way too fast. It's just it's an old habit, and I like to just kind of suck in whatever I can from a page and move on. Disaster when it comes to multiple choice questions. Again, every point counts. Some of you may read too slow, very deliberate, and you can overanalyze if you go too slow. You got to find the right pace. And don't worry incessantly about the clock, because it's really not 1.8 minutes per question. You're going to have a little Civ Pro question that has a fact pattern of 50 words. And you know it or you don't. It takes you 15 seconds to answer that question. And then you got that great contracts or property question. Longer fact pattern takes you a little bit. So don't get too mechanical about the timing, particularly at the beginning. If you're going too slow at the beginning because you're really trying to learn how to answer the questions, so be it. You know, think about a little kid. A little kid has to crawl before the kid can walk, before the kid can run. So don't try to run right from the get-go, because you're going to just miss a lot of questions that you would otherwise get right. Any questions, generic kind of multiple choice questions at this point? Okay, so let's take a look now at the sample question, and then you will do some questions. Okay. Basic fact pattern, and you know, again, because I start up at the top, it's just how I do it, but we've got some people, and there are things packed into these questions, and you should be circling them and saying, oh wow. So we've got a 5-year-old girl. What do you think about right away when you see a 5-year-old girl? We might be attractive nuisance. You're thinking torts, that's good. And 5 years old, where else is age in torts really relevant? Well, contracts, yes. And you might not know that at this point. But if this is a torts question, and if the kid's 5 years old, think about Garrett versus Daly. Probably don't remember the name of the case, but there you go, Annabelle, exactly. How old was he? 5 3/4 years old. So I'm giving you clues, and they will give you clues. Where am I going? So I'm looking at that age, and I might say, oh, it could be a minor. We don't know where it's going yet for contracts purposes, or we could have an intentional tort, and the kid's 5 years old. Now, she runs into the front lawn of the house next door. In doing so, she has done what? Trespass, yeah. We don't care how old she is. Now, she's committed a trespass. See, you write that down. In the end, the trespass is not going to be the key here, but you've got to interact with the question. Then, the owner of the house is on the front porch with his 7-year-old son. By the way, I took this case, this question from a real case. It's a note case in the Prosser case book. In the real exam, almost all of the questions will be based on real cases. That's how the National Conference of Bar Examiners drafts questions. So the more that you recognize cases that you may have studied, the better job you're going to do of answering the question. Because what's the right answer? The holding in the case. Funny how that works. So now we've got a father and a 7-year-old son. So if age didn't hit you when you read 5-year-old, it's hitting you over the head now. And the boy sees the girl dart onto the land, onto his yard. He grabs his bow and arrow. So you know where it's going now. If you didn't know it was a tort before, it's going to be. He goes to the edge of the porch and he says, if you don't get off the lawn in front of my house, I will shoot you with the bow and arrow, which is it's assault, right? And that's not going to be the call of the question, but it is going to matter for the call of the question. So we have assault. And he is intending merely to frighten her. Important to assault because? Very good. Transferred intent. Now, some of you may have learned, did any of you learn the restatement definitions of intent for assault and battery? Or did you learn it sounds like you learned the common law. The restatement combines the two. It depends on the professor. But for bar purposes, you're going to keep them separate. So you're going to have the intent for assault, which is the intent to frighten, and the battery, the intent to cause the contact. Keep them separate. So he's intending to frighten her. He pulls, and what of course happens? He hits her in the eye, and she's seriously injured. Now, the girl sues for battery. So now we know what tort it is. And the question is, will she win? Now, torts. I challenge anybody, it doesn't matter who you are. You all had a torts class, it doesn't matter who you had torts from. Torts is all about, fill in the blank one word. Elements, thank you. Elements, 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 elements. So if you have a torts question, and as you study your torts material, MBE, Florida, it doesn't matter. It's all about the elements, and you want to approach the questions, whether they're multiple choice or they're essay, by focusing on the elements. And you may not remember all of the elements right now. And I know, you haven't gotten very far in your studies yet, so I'm not even going to ask you to recite except one. Because if I ask you to tell me what the elements of negligence are, we can do that, right? Duty, breach, causation, damages. I don't know why. 50 years from now, when you've been practicing law for a very long time, you will still remember the elements of negligence. It's one of those things that sticks. You probably won't remember very much else about law school. but you'll remember that. What you want to do as you prepare for the exam is make sure you know the elements of all of the basic torts that are presented in your materials. All of the intentional torts, negligence, your product's liability, your dignitary torts. Elements, elements, elements for both parts of the exam. So of course, for battery, we need the intent, we need the act, and causation, which is almost never the problem in these questions. So we're going to focus primarily on the intent and the act. Well, he hit her, right? So the act is pretty easy. Let's look at our 4 choices now. A says, yes, because the boy intended to frighten the girl. Now, notice something about this answer, and you're going to see it a lot when it comes to the new style MBE questions. You're not going to see in many of the choices a nice, neat statement of the rule of law. And oftentimes, if you see a statement of the rule of law, it's the wrong answer, because they've given you the wrong rule. But if you're reading fast and you see a rule, it pops off the page, you say, bingo, I got the answer. So don't be distracted by rule statements. Sometimes they're right, they're the right choice, but oftentimes they're not. This one doesn't have a rule statement. It just says he intended to frighten her. What do we think? If you're evaluating this one, does that have any possibility of being the right answer? Ivan says yes, because? Yeah, transferred intent. Exactly right, which is what I'm going to write right by the side. Now, it looks good, but you got to keep reading because you never know when a better answer might come up. B, yes, because the boy was negligent when he shot in her. Juan says no. He's correct because? Well, good. In torts, a common testing trick is to give you one tort in the call of the question and another choice in the answer. Was this kid negligent? Probably he was. But we don't care because the call of the question is battery, intentional tort. So don't mix and match. Be on the lookout for that in tort. So we know, we say incorrect to B, and you circle negligence. That's all you have to do. C, no, because the boy intended only to frighten the girl, not to hit her. Perhaps a true statement of fact. Is it the right answer? No, because transferred intent again. And D, no, because the boy was only 7 years old.
He was using an instrumentality for his age. That was the point.
Okay, it's a good, actually, Annabelle, that's a good point because he's not engaged in adult activity. He's just using his own bow and arrow, and there is a
Bow and arrow level. I'm not gonna get into it.
but it's a bow and arrow that was his, and kids play with bows and arrows. So I take your point, but you don't want to read too much into it, right? And honestly, in the case in which this was based, it was a bow and arrow, and the court didn't even go off into the adult activity area.
But isn't the adult activity area part of negligence?
Yes, it is. It is. So a very good point. It's another reason why that's not going to be where you want to go. That's actually a very good point. So you got to think all those things through. So we've eliminated D, C, and B, and it leads us to A, which is the right answer. Any questions about how this one worked? All right, now what we're going to do next, you're going to pull out your packets and your clickers. And where'd that thing go? Hang on, let me get that back up there. I'm going to ask you to do one question at a time. You all know with the clickers you can't do more, you can't click more than one. So read question number 1, click your answers, and then we'll see how you're doing. And go right ahead. Thank you, sir. I'll fork. Okay. Thank you. Yeah, if it does, we have lots up here. You all know these clickers are not always functioning properly. Coming up on 2 minutes. Anybody else? All right, I'm going to call it. And let's see how we did. Very good. D is the right answer. But let's talk about why D is the right answer, because not everybody got it right. Now, by the way, as we go through these questions, there will be some topics that you probably haven't studied yet. No excuse. Do them anyway. Because if you do a good job of reading, you may be able to get a question right where you really don't know the law, because you can eliminate. And that's a skill. We all want to hope that we know everything when we walk into the exam. It's not possible, folks. And I told Annabelle earlier, I've been doing this a long time, and every exam, every 6 months, I go, wow, how did I not know X? I learned something new every time. So you can't know everything. You still have to try to answer the question. But on this one, it is a pretty simple question, all things considered. And don't get the idea, of course, that torts is going to be that easy. But it's a good one because it illustrates some of the most important points in terms of analyzing torts questions. So, again, a question that's taken out of a note case in Prosser. You all had the Prosser casebook. You know how many note cases there are. The examiners are going to that same well. They are using those cases, and if you know the holdings in the case, you're going to get the right answer. So we've got a teenage boy. He becomes fascinated with the music of a particular band, and his fascination grows into an obsession. He loses touch with reality, commits suicide. Now, his mother wants to bring a wrongful death action against the band based in negligence. If you didn't circle or underline or do something with negligence, obviously you didn't do a good job of reading the question. Will the mother succeed on her claim? Right away you think duty, breach, causation, damages. In that order, by the way. Sometimes when it comes to elements, like when we get to adverse possession later, doesn't matter what order you do the elements in, but with negligence it does. Because if there's no duty, there's not going to be a breach. And who cares about causation or damages? So always in that order. Now, in this particular question, we'll see which element we're talking about. A says, yes, because the boy died after listening to the band's music. What would you say is missing from that choice? Nobody picked it, but what's missing? Duty, breach, causation, damages. What's missing? Causation, right? Doesn't say anything about causation. So what you have to do when you read these answer choices. B, yes, because the death of the son caused the mother severe emotional distress. Could be a true fact, but it's not right because the wrong tort. Exactly right. We don't need severe emotional distress for a basic negligence cause of action. C, no, because the band did not intend to cause the boy's action. A couple people picked C. You weren't reading carefully. What did you miss if you picked C? Intent. The call to question is negligence. Intent is not an element of negligence. Elements, 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 elements. Drill it into your head, which leads us to D, no, because the mother can't prove that the band's music caused, and that's the key right there, caused the boy to commit suicide. No causation. Any questions? And by the way, the analytical answers to all of these questions will be posted on the web course. So I encourage you to download those when we're done. All right, question number 2. Did it work? Yeah. Yeah, I don't think it registered. Yeah, now you did. Okay, we're going to call it a longer question, right? And contracts, which is also going to be a tougher one. And on top of that, the dreaded 2207. Ah, interesting. Now, you may not have, anybody spend time thinking about 2207? Oh, a few of you did, okay. Ah, interesting, we got a couple in the back. It's tough, 2207. There's another taken, right out of a real case. And will they test 2207? The answer is absolutely yes. So you put in your list of things to study, and all the bar courses will tell you the same thing. You have to know 2207, and what's really scary, they like to test 2207 on the essay portion as well. Ah, yeah. So spend some quality time with your friend 2207. So let's look at the fact pattern. Since we were all over the place, which is kind of interesting. And the right answer, just so that you know, is B.
It's B.
B. Ah, yeah. So let's see how we get to B. Okay, so if it's a contracts question, by the way, what do you have to decide right up front? Whether it's essay or multiple choice, governing law, folks. Always, always, always governing law. And of course, it starts out involving a sale of glass jars. So we know what applies? Okay, yeah. I always say Article 2. UCC is fine. I say Article 2 because there are 9 articles in the UCC. It's goods, right? Goods are all things movable at the time of identification to the contract. And glass jars, you can pick them up and move them, right? So right away I'm going to write Article 2 because the rules are very different. Mirror image rule doesn't apply here. 2207 applies. So there's a purchase order form which should give you a hint where the question's going right there. And it says how many, which of course is essential, right? Because what's the one essential term under Article 2? Quantity, right? And then some other things, price and delivery terms, but no other terms are included. Now, manufacturer responds with an order form that limits the statute of limitations, which is 2207 terms, it's a what? Additional term, right? Even if you called it a different term, you end up with the same answer. But yeah, it's an additional term, right? And processor didn't respond, but the jars are delivered. Now, this is a fact pattern that you're going to see in some of your multiple choice questions from your courses. And sometimes people get this wrong. But here's how the case law really goes in this area. So we've got, in our steps in 2207, first, was an agreement formed? 2207 subpart 1. Is there an agreement on something? Yeah, quantity, price, some other stuff. Now what do we do, subpart 2, with the additional term? First thing you want to ask yourself when you get to the additional term is what? Are they merchants? Both parties have to be merchants. Now, in Article 2, there are 13 merchant provisions, but only 13. Article 2 applies to everybody. If I sell somebody one of these lovely clickers, I'm not a clicker merchant. I'm assuming you're not a clicker merchant either. Article 2 still applies. But there are special provisions for merchants, and when you get to those merchant provisions, make sure you know whether both parties have to be merchants or just one. 2207 subpart 2 says, as between merchants. So both parties have to be merchants. Are they both merchants here? Yeah, they are, because they deal in goods of the kind, these glass jars. Next question then is, what do we do with the additional term? It becomes part of the agreement unless the offer was limited to its terms. Not true here. It's a material alteration, or the offeror fails to object when? Reasonable time. Don't confuse it with 2201 subpart 2, which is the merchant's exception to the statute of frauds. That's your 10-day rule. Here, it's a reasonable time. So we know the first exception, there's no limit in the offer. It comes down to whether we have either a material alteration or a failure to object within a reasonable time. But what a lot of you seem to think, processor waited 15 months, that's outside the statute of limitations. It's based, I'm guessing, on the notion that by accepting the goods, that acceptance of the goods was also an acceptance of the additional term. Not so. And there's case law, and I just taught it again this semester. It hasn't changed. The fact that the goods have been accepted does not mean that the additional term has been accepted. You've got to separate them out. Is there anything in the fact pattern that shows acceptance of the additional term? No. What about that additional term? It's a change in the statute of limitations. Is that a material alteration? Yes, it is. What are you going to look for in terms of material alteration, by the way? You're going to look for change in the statute of limitations. It's always going to be a material alteration. You're going to look for a disclaimer of warranties or a limitation of remedies. Those two kind of go together. And the third thing is an arbitration clause unless it's the custom of the industry. That's where all the case law is. And so that's what you're going to be looking for in terms of a material alteration. So again, if you picked D, it's likely because you equated acceptance of the goods with acceptance of the term. They're different. Any questions about this one? Yeah, 3 things, absolutely. And again, it's all based on case law, but that's how they're going to test. The first is what you see here, is change in the statute of limitations. And by the way, of course, if this term is not part of the agreement, we use the default under Article 2, which is how long? 4 years, right? So any change in the statute of limitations is a material alteration. Any disclaimer of warranties, oftentimes coupled with a limitation of remedies, that's a material alteration. The third, there's a ton of case law on arbitration clauses. And an arbitration clause, generally speaking, will be a material alteration unless it's the custom of the industry. It's the custom of the industry. It's the way they always operate. It's not going to be a material alteration, right? But they're going to have to tell you that it's the custom of the industry. Otherwise, it's not something you would assume. Any other questions on this one? Make sure, again, that you spend some time reviewing 2207. And remember the rule I just told you. Make sure you separate out acceptance of the goods from acceptance of the additional term. They are not the same thing. Okay, number 3. Anybody else? All right, let's see how we did on the first con law question. Oops, I gotta stop that too. Pretty good, but not perfect. D is, of course, the right answer. Let's talk generally about con law, and then we'll talk specifically about this question. Con law is going to be based on two things, the obvious two things. You're going to have the Constitution, and you have to know the Constitution, and you're going to have a bunch of case law. And the more cases that you know in this area in particular, the better off you're going to be. Think about it this way. If you're going to test constitutional law for the purposes of the bar exam, how are you going to know what the right answer is? You know, the Supreme Court, they get up in the morning and they say, okay, here's the answer, you know, because they're the Supreme Court. The only way you can know what the right answer is to know what the holding in the case is. Your professors may have tried to stretch you into, you know, think beyond the existing cases, but they can't test that way. They must test based on the cases or just what does the section say. It's the one area where numbers matter. And what I mean by that is, you know, when it comes to contracts, you're going to hear me as I talk about contracts. I spout Article 2 section numbers. That's the first thing I say. It's how I learned Article 2. The number tells me the rule. But for the purposes of the exam, do you need to know the difference between 2205 and 2207 in terms of numbers? No. But when it comes to constitutional law, do you need to know the difference between privileges and immunities under Article 4 and privileges or immunities under the 14th Amendment? You bet. You've got to know the numbers and the names when it comes to con law. And again, the more cases you know, the better. Now, when it comes to con law in terms of how you think, first thing you want to do is go back to your con law class. Con law 1 is all about the powers, right? Con law 2 is all about individual rights. Same thing when it comes to the exam. This question is kind of straddling the line because we're talking about powers to a certain extent when we talk about Article 4, but we're also talking about individual rights as well. So let's consider what's going on here. And if you got the question wrong, it's one of two things. Either you didn't remember the rules exactly right, or more likely, you just didn't read carefully enough. Because we've got fishermen, they're fishing, and the economy in the state is suffering, so the state steps in and that enacts a statute governing fishing in the state lakes. And it says no person or business entity is permitted to fish the lakes for commercial purposes without a license. No person. So you got to have a license. Commercial fishermen from the state pays $1,000, out of state $5,000. So right away, as soon as you read that, you're thinking Commerce Clause, right? Because we're discriminating against out-of-state commerce. Fisher is a commercial fishing corporation, which should tell you something. Does it matter for purposes of the Commerce Clause? For the Commerce Clause, it doesn't matter, right? But for privileges and immunities, it does. The difference in how a person is defined in con law matters a lot. So make sure that you focus on that. Sometimes a corporation is a person and sometimes not. And for purposes of Commerce Clause, we don't care. For purposes of Privileges and Immunities Clause of Article 4, we care a lot. So Fisher is charged the out-of-state fee and wants to challenge under the Privileges and Immunities Clause of Article 4. As most of you figured out, nope. Fisher is a corporation. Commerce Clause challenge might be available, but not privileges and immunities. Now, let's look at the other choices. A, it's a juicy statement of law, and it's a correct statement of law, but it's not the right one. Because do we care about the market participant exception here? No, for two reasons. First of all, Fisher has no standing because Fisher's a corporation. And second, was the state acting as a market participant? No. So be really careful. As I said at the beginning, don't jump on a juicy statement of law. You get so excited you recognize a rule. It's usually, not usually, but oftentimes the wrong answer. B says, yes, because the pursuit of a livelihood is an essential activity. Yes, it is. All you have to remember is the attorney case from Virginia. Yes, the pursuit of a livelihood is an essential activity. It's different, right? Because that pursuit of a livelihood is not a fundamental right, for example, under the 14th Amendment, but it is an essential activity for purposes of privileges and immunities. But once again, we don't care. Corporation. And then C, I like to keep this answer choice in. I'll explain why. It doesn't have the same meaning that it did years ago when I was teaching this stuff. It says the courts have never found a statute unconstitutional under the Privileges and Immunities Clause of Article 4, which is, of course, exactly wrong. But it's there for a reason, because up until the Sands case, the Supreme Court had never found a statute to be unconstitutional under the Privileges or Immunities Clause of the 14th Amendment. Now, Sands, having to do with welfare rights, changed the ballgame. But what this is here for is a couple of things. Never found? Probably already figured out that you have to be really cautious about absolutes. Usually it's going to be the wrong answer, not always. Because, for example, you could have a really simple civil procedure question that says that a prayer for relief must always be included in a complaint. Yes. And you might have an evidence question. The defendant always stops at every stop sign. Habit, right? So absolutes sometimes are right. Usually they're wrong. Always be cautious, and that should have told you something there. And the other point is to distinguish between privileges and immunities under Article 4 and privileges or immunities under the 14th Amendment. What does Article 4 deal with? One state is discriminating against citizens of another state. 14th Amendment, the state is discriminating against its own citizens, denying its own citizens the privileges or immunities of national citizenship. Voting, travel, which is the Sands case again. Basic right to the protection of the U.S. Marshal. I love that one. I don't know why. It's on the list. Will they ever test it? Kind of doubt it. But right to travel. Be keyed into the right to travel, because it's a hot topic with the Supreme Court, and it shows up in so many places. You want to think about those buzz topics that you learned in your con law class, because that's what they're likely to test on the exam. Any questions about this one? All right, next question then, number 4. Okay, anybody else on number 4? All right, let's see how we did with property. What? Okay. Oh, yeah, okay. You were going to pick the right one, right? D is the right answer. Now, this was a tough question. It's off the screen, but D is the right answer. It's actually a very easy question if you read carefully. So a couple of comments. First of all, property. Yeah, I see some faces out there that I've had in property class, and I know most of you don't like property. There's no way to make it a whole lot of fun. Most of it anyway. But you know, don't give up on it. If you didn't like property the first time, Annabelle's face is classic. She didn't like property. You know, don't give up on property. If you didn't get estates and future interests, you will live. You can actually pass the bar exam without knowing estates and future interests. But adverse possession, wow, you got to know adverse possession, right? That's not rocket science. And they test adverse possession a lot on the Florida portion as well. So there's certain things, landlord, tenant, adverse possession, your basic conveyancing stuff, recording. All of the above. And now, by the way, they changed the outline, and they're going to be testing more in the area of zoning and taking. Now, for those of you who had me for property, we got there because I think it's important stuff. Some of you may not have had zoning and taking in your property class. Make sure you put more focus on it, especially taking, because they test that on both parts of the exam as well. So I left this particular page up on purpose because it gives you the whole key to the question. We're talking about adverse possession, and there's a statute. If the question gives you a statute, which it may well do in property, also criminal law is another area where they're likely to give you a statute, then you apply the statute given. This statute happens to embody the correct rule, but sometimes they'll change the rule, use the rule that's in the statute. And so it says the statute of limitations is told, and the owner must bring suit within 7 years in respect to a, excuse me, a disability that's removed. I'm having trouble reading. You know what? It's easier to read this way. So the suit must be brought within 7 years or within 10 years from the removal of the disability in existence, which I don't have up there. That's part of why I was struggling. In existence at the time the cause of action arose. That's the rule. Disability may be taken into account under a tolling statute, but only if it exists at the time the cause of action arose. And in this case, did it exist at the time the cause of action arose? No, it didn't. So, because if you take a look, possessor enters in year 1, and then in year 3, owner is adjudicated incompetent. We don't care. The statute just keeps right on rolling. So then, what do? Let's get the answer choices up there. Once again, the correct choice, which is D, is couched in terms of the facts, not the rule. But the fact that possessor entered in year 1 before the disability arose, that's the right answer. A, no, statute of limitations was not told in this case because the disability arose after the possessor entered. B, owner gets 10 years after the removal of his disability. Not correct here once again because the disability arose after the possessor entered, and we don't care about the removal of the disability, which is what C addresses, because it wasn't in existence at the time the possessor entered. And the statute that you have there tells you exactly what rule to apply. Yes, ma'am.
Maybe it's a typo in the question. It's on the first paragraph. It says in year 3 the owner was adjudicated incompetent, and in year 5 the owner was adjudicated incompetent.
Oh, it's supposed to be. Yeah, you know what? Wow, it's year 3. It wouldn't matter whether it's year 3 or year 5.
Okay, I know.
But thank you, because that's. I'm not sure how that happened because that wasn't there before. It's just it repeated the fact and bumped it ahead. Year 3 is what it's supposed to be. Thank you. I will get something to write with, but I'll correct that for next time around. Thank you, Annabelle. And let me just say something.
No, it's actually he was adjudicated incompetent and then competent. So
Oh, he was adjudicated competent. See, I didn't look at my own facts. I should read my own facts. See, he was adjudicated and then he was rehabilitated, and that's the removal of the disability in year 5. Now, got to read the facts carefully. Obviously, I didn't read my own facts. I wrote the question, but I didn't read my own facts carefully enough. And, however, I want to urge you. Challenge the questions. You will. I promise you. You're going to get questions, and you're going to go but, and a lot, and challenge. Ask me about them. You can email me the question. You can scan it and email it to me, or you can type it and email it to me. Ask about it. Don't say, oh well, I guess I was wrong. If you think you're right, you might be. Sometimes the questions aren't right, or it's old law, or something like that. Or sometimes, like this one. If I read it carefully, I'd say, wait a minute, the sentence says. So always ask, get the feedback. Okay, other questions about this one? Number 5. Anybody else still working on this one? All right, let's see how we did. Very good. However, not everybody got it right, so let's take a moment. Evidence, as I mentioned before, evidence, the questions are going to be shorter for the most part. And what you want to do with evidence, here's a place where I don't start with the rule number. It's a weird sort of thing. I didn't learn evidence by rule number. I learned it by substance. But you also don't want to try to go to the rule first. That's one of the things people really struggle with evidence. You got all these rules swimming around, and how do I separate them out? There's a 3-step process that was developed a long time ago, but it really works in terms of how to conceptualize evidence. So give it a go. First step is to identify the type of evidence, which is usually pretty easy. Is it real evidence, the murder weapon? Or is it documentary evidence, the contract? Or is it testimonial evidence? Whatever it is. And be as specific as possible in identifying the evidence. Because if it's testimonial, what is it? Is it a prior inconsistent statement or something else? And at that point, you may also have to think a little bit about privileges. Once you've identified what it is, you come to the second step, which is the key to the process. If you get the answer to the second step right, you'll get the answer to the question right. That second step is to ask, what is the evidence being offered for? And you have to be really critical here. Number 1, assume that it is not being offered for the truth of the matter asserted, which means it's not hearsay. And if you think back to your evidence class, you probably spent most of it talking about hearsay. Everybody goes right for the hearsay answers. It's usually the wrong answer when it comes to the bar exam. So think of everything else. Is it being offered to impeach? Is it being offered to show ownership or control? All these other ways that evidence that looks like it would be hearsay can come in. And in making that analysis, again, be very critical. Is the trial civil? Is it criminal? Is the evidence being offered by plaintiff, defendant, or prosecution, defense? Is it being offered on direct or on cross? Because all of those rules that you're trying to apply, they're going to make you make those distinctions. So again, be specific about what it's being offered for and when it's being offered and by whom. And if you get to the end of that process, then you say, is it admissible or is it inadmissible? Well, usually, if you've thought it through, going through all those steps, by the time you get through the steps, you know yes or no. If you go right to the rule, you're going to sit there and you're going to fret for a while, particularly when it comes to that awful thing called character evidence. And what I want to beg you to do with character evidence is to not think about it as this big blob, this big behemoth. Because that's what gets everybody confused. You break it down. Criminal versus civil, right? Because civil, character evidence usually doesn't come in except for certain things. Criminal, character evidence is a lot more important, right? It's being offered by prosecution or defense. And what's it, and is it on direct or is it on cross? All of those questions will help you pinpoint the rule that you want to apply. So if we start with this question, and it says that, what's his name? He always, Driver always makes a full and complete stop at every stop sign. So this is going to be testimonial evidence, right? What's it being offered for? I'm sorry? Habit, yeah. Yeah, it's habit. It's not hearsay, right? It's habit, because habit is outside the realm of hearsay. And since it's habit, if it's always, inevitably, never, those absolute words we talked about before, that's what makes it habit and not just character evidence. And is habit evidence admissible? Yes, it is. So take yourself through those steps, really try to work through what it is and all of those parameters. What kind of trial, who's offering it, when is it being offered, and it's going to help you get to the right answer. Okay, number 6. All right, I think we're all in. We're at the 2-minute mark in any event. Dos minutos, folks. All right, pretty good. Now, civil procedure. A couple of things to keep in mind as you look at the question. If it's a civil procedure question, it's still going to have likely some substance mixed into it, because civil procedure doesn't operate in a void. And what I've heard from people who have taken the exam since CivPro was added, that's what throws them off about the procedure questions. They get hung up on the substance rather than the procedure. So how do we know this question is about procedure rather than substance? Well, look at the facts. I kind of overloaded it here because we've got an automobile accident in the Northern District of State A. So, right, if it's just a torts question, who cares if it's in the Northern District, right? So that's telling you. And then plaintiff resides in the Southern District. Well, by now you know. It's really not about the auto accident, it's about the procedure. Then we've got the defendants in different states. So if you were in doubt, which most of you probably were not, it's a CivPro question. Now, plaintiff seeks to sue in federal district court based on diversity of citizenship. Why is that sentence there? Because then you have to apply the federal rules of civil procedure. The good news is when it comes to the MBE portion of the exam, they're not going to give you state law. So you are going to be applying the federal rules, but always check to make sure. And do we have diversity here? Yes. And the claim is for $250,000, so we have the amount in controversy. Call the question says venue is proper where? Most of you did pick A, which is the default rule. It's not the first rule that you go to. And so there are layers in this question. It's actually a harder question than you might think, even though you all did a good job and most everybody got it right. So we have to come back to A. It's a possibility, but you can't just say, yes, that's the right answer. Because first we want to look at what? Where, who resides? The defendant, yeah. We've got to look at the defendant first, which means, of course, that B is going to be wrong. We don't care where the plaintiff lives for the purposes of venue. It's where the defendant lives. And we do know that defendant number 1 does reside in state C and defendant number 2 in state D. But what's the problem with that for venue? They have to all reside in the same state, and they don't. And because they don't, then you default to the location where the accident occurred. And I'm guessing that you all, shake your head yes, shake your head no, you all kind of intuited the process. Did you really go through the steps that I just went through? Now, you got to slow down and take yourselves through the steps, because if you just kind of say, oh yeah, I think I remember, you might get it right, but you might not. If you walk through the steps, and as you go through these other choices that they're wrong, then it verifies that A is indeed the correct choice because we need to use the default rule. Okay, number 7. Anybody else on this one? All right. Let's see how we did. Okay, pretty good. Not perfect, but B is the right answer. Now, this question has more layers, again, than you might think, and you got to go through all the steps to get to the right answer. First off, it is based on a case from Prosser, but I kind of changed the facts a little bit. The case, its case note, involved a car that was driving on an unlit road in the countryside. And a car came over the top of a hill, and as it came down the other side of the hill, it hit a cow, a black cow, and killed the cow. And the driver just kept on going and left the cow in the middle of the road. So another driver came along, came over the hill, couldn't see the black cow because the road was unlit, and plowed into the cow and suffered damage. Driver number 2 sued driver number 1. I thought it was a little too gory. I don't like dead cows. And so I kind of changed the facts. This is something that actually happened to me when I was a kid. A bunch of suitcases on top of a station wagon back then that blew off all over the road. So the question is, how do we analyze this particular fact situation? There are 2 duties. Duty number 1 is the duty to tie the luggage properly to the top of the car. And in the case that this actually came from, duty number 1 was to drive carefully. From what you can tell from the fact pattern, did our driver violate duty number 1? No. It appears that the suitcases were properly tied, which was the case with the car. Coming over the hill, the driver was driving with care. The road was unlit, the cow was black. What are you going to do? But duty number 2 arises once you hit the cow, or in this case, once the suitcases scatter across the road. So now think about this. We all want to get out of here as soon as possible. We pack up all our stuff. You got your bottles of water. I got my Snapple. You walk out to your car. You know, your hands are full. What do you stick the bottle of water or the Snapple or the whatever on the roof while you open up the trunk, right? We all do it, right? And you throw your stuff in the trunk. You get in the car and you start to drive away. And as you're driving away, somebody in the parking lot's going like this. You're laughing because it's happened. Okay. It does. My brother-in-law got all the way out on the highway once with my niece who was really little at the time, going, "Daddy, Daddy, Daddy, Daddy." He said, "You know, shut up, I'm trying to drive." He had left his cup of coffee on top of the car, and they were on the highway. So it does happen. But if you're in the parking lot and somebody's going like that, should you probably stop and get, particularly if it's a glass bottle like that? Yeah, because it could fall off, it could hurt somebody or damage some paint or something, and you're just in the parking lot. But if you're on the highway, if you manage to get all the way out on the highway like my brother-in-law did, if I'm trekking on the Palmetto and I'm heading home and somebody in the next lane is going like that, am I going to stop? No way. I'm not anyway, not on the Palmetto. Not me, on the Palmetto. So the key here is the absolute words, right? Because we know we have a duty, but the duty isn't absolute. And if you look at your answer choices, that's the key on this question. Let me get okay, so A says, yes, because a reasonable driver would always stop. Not always. It's a reasonable driver in the circumstances of the defendant. And it just depends. So always is problematic there. B, which is the right answer, drivers should have foreseen that a motorist could be endangered. Yeah, that sounds like good tort language, right? C, no, because a reasonable driver would not stop. Again, you're absolute. Either side is not good. And then D misses the fact that you had 2 duties. Because D says the driver could not have foreseen that the suitcase would come loose. True statement. But that's just duty number 1. We're focused on duty number 2. So careful, careful reading. Now, question for you. We are halfway through the questions. We can take a short break. We do because of the library and the equipment and everything. We have to be done by 6, and I know you all want to be out of here by 6. Even if we take a break, we'll be done by 6. We can speed it up by 10 to 15 minutes. If we don't take a break, your call. What would you want to keep going? Okay. You're free to step out if you need to, as you have been doing. There's probably still pizza and water out there if you need a little refreshing. If we aren't going to take a break, let's keep rolling. We'll get done sooner. Number 8. Okay, we're hitting 3 minutes. Anybody? Okay. All right, let's see how we did on this one. Contracts again. Yeah, kind of all over the place. It's one of the reasons, the answer is D. One of the reasons why I like to do this question. Yeah, I'm sorry. Because of the projection, it's D. So, first things first with this question. Governing law, easy, right? Article 2. You need to write it down, though, folks, right? Because, again, we're going to be talking about an Article 2 rule, 2306 in particular, and it's a requirements contract. Now, we know with the requirements contract that the buyer cannot make any unreasonable demands. And as you read the fact pattern, you're saying, oh, buyer's not taking anything at all. That's a big, and of course it's very different from previous purchases. And if you have an estimate, the estimate is going to be the bell, if you will, around which the purchases are measured. And there's nothing taken here. So your inclination, many of you, was to say that's an unreasonable demand. But that language has been read really strictly to mean that demand means asking for a lot more, but does not apply to asking for a lot less. So what do you do if there's a demand for a lot more and it's disproportionate? Then it's going to be unreasonable. If there's a demand for a lot less, nothing in this case, then all the buyer has to do is act in good faith. How do you know that the buyer has acted in good faith in this type of situation? If the buyer is just, and you listen carefully to what I say, because it's not going to, you're going to say but here's how the rule goes. If the buyer's just trying to save money, it's not good faith. If, on the other hand, the buyer has shut down the business, which the buyer did in this case, it is good faith. Of course, then you're thinking, well, but if you're shutting down to save money, isn't it the same? It's the case law.
Just a quick question. So, like, the defense of impracticability and possibility plays in here, or not?
No, not in this case. It's a good question, and it could, but not in this particular case.
So what do you base it on? Like?
It's just right on 2306. just that language. There is a whole line of cases, and what's interesting is it never used to show up in the case books, but the most recent edition of Calamari has case books are starting to pick up on this particular point, maybe because the bar likes to test it. You don't have to get to impracticability, impossibility, frustration of purpose in this particular case, because you look at the language of the statute, statutory interpretation, unreasonable demand in the statute. Because remember, it does, 2306 subpart 1 does say that the buyer may not make unreasonable demands. That language is restricted to asking for more. If you ask for less or nothing at all, it's not a demand language. Then all you have to do is act in good faith. You always have to act in good faith. Every provision in every contract must be carried out in good faith. And good faith includes shutting down or not asking for anything if you completely shut down your business. It does not include, well, I just need to save some money or I could make more money some other way. Yeah.
You read the language also to understand that because it's a requirement contract and they don't have any more requirements, then
It's not unreasonable.
it's not a
Right, exactly right, exactly right. Okay, any other questions on this one? Again, I include it because it seems to be something that gets tested a lot. Right, number 9. Anybody else on number 9? All right. Pretty good. For those of you who picked D, which is the, yeah, we got in the right place now, which is the right answer, there's a key phrase in there. What'd you pick up on that just answered the question for you? Well, it's controversy. The question is it moot or is it live? It's a what? The plaintiff brought a class action. The question's easier than some of you made it. You got the right answer, most of you, but it's a class action. If it's a class action, the name, and which Roe versus Wade is the best example. Well, that too, but she was no longer pregnant at the time the case was decided. It didn't matter because there were other members of the class. She brought it as a class action. And yes, of course, you also want to think about capable of repetition yet evading review, both of those things. But I telegraphed there by making it a class action. See how important it is to read carefully. How many of you just, and I know, see, you're getting tired. And that's one of the things you have to be careful about. How many of you actually paid attention to the fact that it was a class action? Okay. See? How much easier the question was if you read carefully. Now, you gotta, and when you get tired, and I can see it in your faces now, not understand, you know, it's not surprising because we've been sitting here for a while. The last few questions, I'm just going to tell you, pay attention. Because when you get tired is when you make stupid mistakes. Now, are you going to get, when you get to the exam, are you going to get every question right? No. Are you going to know every rule? No. Are you going to make stupid mistakes? Let's hope not. You can't control the fact that you don't know every rule. You're just not going to know everything. Nobody does. Can you control the fact that you make stupid mistakes? Yes. Don't make stupid mistakes. And that, when I say stupid mistakes, reading comprehension, the easy things that you can control. Just a heads up. Okay. Next question then is number 10. Okay, anybody else on number 10? All right, as I'm pulling up the results, let me ask you first, how many of you took Crim Pro? Okay, those of you who took Crim Pro, just Crim Pro 1, how many took Crim Pro 1 and 2? Okay, that's a Crim Pro 1 question, but just be aware, Crim Pro 1, 4th and 5th Amendment, part of the Fifth Amendment, but only part of the Fifth Amendment. There's a lot of the Fifth Amendment, double jeopardy, and Sixth Amendment stuff that you did not cover in Crim Pro 1 that is fair game for the exam. And for those of you who did not take Crim Pro, make sure that you spend a little more time reviewing it, because it's tested, of course, on the MBE, and it has shown up recently on the Florida essay exam. The good news, of course, in Florida, our Florida Constitution, as you'll learn from Judge Shepard, expressly provides that we must construe our search and seizure provisions in conformance with the Fourth Amendment of the U.S. Constitution, so there's no difference in the rules. Okay, the correct answer is C. Now, let's talk about why it's the rule. It's just, you can't necessarily intuit your way to the right answer when it comes to U.S. Supreme Court cases. They just decide things the way they decide things. And that's maybe being a little, I don't know what the word is, but the fact of the matter is the Supreme Court will do what the Supreme Court will do. So, in this particular case, guest is not an overnight guest, and that's the key to the case law. You have to be an overnight guest to have standing. Guest is just there for the afternoon. And a number of you picked A, yes, because guest was a social guest. Not good enough. You got to be an overnight guest. So that's probably not knowing the case law. And if you didn't take Crim Pro, you wouldn't know that case law. B says yes because guest was not named in the search warrant. A true fact, but we don't care because they weren't searching guest. Guest is just sitting on the floor near the bags. And so guest doesn't have to be named in the search warrant because they weren't, again, searching guests. C, of course, is right because guest was just visiting, not overnight. Nobody picked D. No, because guest was not named in the search warrant. Once again, that's irrelevant in this particular case. So, word to the wise, because I saw a number of people who didn't stick their hand up. If you didn't take Crim Pro, spend some quality time with it. And even if you did, make sure that you don't say, okay, I know Crim Pro, because there's about half of it that you did not, that's testable, that you didn't cover in your class. And cases, plus a little bit of Constitution there. Okay, number 11. Okay, anybody else on this one? Okay, let's see how we did. Now, recording. Everybody hates recording, right? And it's no picnic to teach, let me tell you, because it's hard. They will test it on the MBE, and it shows up a lot on the Florida essay. Oh yes, it's oftentimes included as a component in a Florida property essay. So make note of that, and make a little note that Florida is a notice recording statute, because that'll help. Now, where do you start if you have a multiple choice question dealing with recording? They have to give you a statute. And this particular statute is what kind? It's not going to, by the way, race is too easy. Whoever gets to the courthouse first, they never test that, right? They're going to test notice or race notice. Which do we have here? It's good. It's race notice. Now, I know what some of you went to, but there's more that you want to pick apart, if you will, in analyzing the statutes. A lot of you probably just went to the first dually and said it's race notice. Not quite good enough. You want to know how many people have to record. The statute's going to tell you. If the statute tells you just one person needs to record, it's a notice statute. If it tells you two, it's a race notice statute. If it tells you just one person needs to record, it's telling you the first person needs to record to be protected against the second person. If it's telling you two persons need to record, it tells you the first person has to record to be protected against the second person, and the second person has to get in there first and record. So you're going to look for, in most instances, you're going to look for some form of the verb record. If it's there just once, it's telling you just one person has to record, the first person. If it's there twice, it's telling you that two people have to record, the first person and the second person. One person has to record, it's a notice statute. Two, it's a race notice statute. Now, once you've, and it's absolutely essential that you identify correct, because that's going to make a big difference, right? Once you've done that, then you will ask yourself a series of questions. And these questions, again, especially because I do like to test it in essay form in Florida, it's a really good way to write an analysis. The same first three questions, whether it's notice or race notice, and you add a fourth question if it's race notice. First question is, who is subsequent? Who took later in time? You identify that person. Second question, was that person a bona fide purchaser for value? That's usually pretty easy to spot. They're going to pay, or they're not going to, or it's going to be a gift. Third question, who takes without notice? Notice, actual notice, you saw the deed. Constructive notice, record notice, you get notice from the record, or inquiry notice, something about the land. If it's a race notice question, those same three questions, who is subsequent, who took later in time, was that person a bona fide purchaser for value, without notice, your third question, and the fourth question, who recorded first. So we ask those four questions in this particular case. Now let's look at our answer choices. Well, actually, let's look at the fact pattern. So owner conveys to purchaser. Purchaser is number one, right? And purchaser promptly records, which means we have record notice, right? And so whether it's notice or race notice, purchaser is protected at this point. In year 8, owner conveys to vendee. That's number 2. Vendee didn't record. Oops. If vendee didn't record, and it's a race notice statute, vendee's not going to win, right? So we look at the statute, and the statute tells us clearly that it's a race notice statute. Now, if your subsequent person, that's vendee, doesn't qualify under the recording statute, which is the case here, because vendee didn't record first, plus vendee had record notice anyway. If your subsequent person isn't protected, what rule do you use? Common law, first in time, first in right. Who's first in time here? Purchaser. It's not that hard, right? Well, It's not easy, but it's not that hard. So purchaser has to win here because we're going to apply that common law rule. And that's answer choice D. Purchaser took the parcel before vendee. A is wrong because it says vendee didn't have notice of purchaser's deed. That's not correct. It was recorded promptly, which means it's in the right place. B, yes, because vendee took the parcel subsequent to purchaser. Well, it's a true statement of fact, but it doesn't go through the steps we just described. And C, no, because purchaser paid value when she took her deed. Lovely, you have to be a purchaser for value to be protected under the recording statute, but you need more. So if you take those steps, 3 steps for notice, 4 steps for race notice, you can get yourself to the right answer. And I promise you this, you practice some recording statute questions, and you get it down, you are going to pick up points that a lot of other people will not get. Most people do not get recording. They didn't like it in law school. They don't want to bother with it for the bar exam. And that's the name of the game. You, not here, people who are from Nova, the people who are from FIU, you want to get more points than them. The more points you get that the other person didn't get, the more likely you are to pass.
I was taught by the best. By you.
Oh, well, thank you. But I promise you, use these steps, and it works. And you get, again, you get those points that other people don't get, and that's how you pass the exam. All right, number 12. Oops, sorry. Sorry, now you can click in. Forgot to do that. Anybody else on number 12? All right, let's see if we're still awake. Not everybody is awake. It's a really easy question, unless you blow the call of the question. How many of you missed the fact that the call of the question says least likely? Or least accurate, excuse me, but still. You missed one word, you get the question wrong. 3 of these statements are absolutely correct, and some of you were puzzling over that because you go, but that one, but that one's, but that one. Yeah, right. 3 are more right. 1 is wrong. Then the one that's wrong, of course, is B. It's a really easy question unless you aren't paying attention. So we're talking about counterclaims. You've got compulsory counterclaims, you've got permissive counterclaims. And if you look at the statements, I'll read this way because it's easier. A, seller must bring a counterclaim against buyer if seller's claim arose out of the same contract. Sure, must, compulsory. But that's not the right answer, because we're looking for the least accurate. B, seller may elect to sue buyer later for breach of contract, but only if seller's claim arose out of the same transaction. No, that's wrong. So that one, that's going to be your correct choice, because we're looking for the least accurate. But then you look at C and D, they're both true statements, because C says seller may bring a counterclaim if the claim arose out of a different contract. Correct. It's the wrong answer. And D, seller may elect to sue buyer later if seller's claim arose out of a different contract. True. Wrong answer. So pay attention to the call to question, especially as you are right now, if you're tired, because that's when you make the stupid mistakes. No one should miss this question. It's too easy unless you're asleep at the wheel. Okay, we have just 2 more. Let's get them right? Okay, number 13. Anybody else on number 13? Okay, and Veronica just handed me her lunch order. You can give me lunch orders if you filled them out, and just a word on that. Do take advantage of the lunch. Maybe it sounds stupid at this point, but the last thing you want to have to worry about when you get there and you don't have a lot of time in between the morning and the afternoon is, where do I go for lunch? Because you are in downtown Tampa, but you don't want to go out and you don't want to have to deal with it. We provide you with a lunch which has been thought through carefully. We give you brain food and nothing that will put you to sleep. And just give you sustenance for the afternoon. And our experience in the past is that people really enjoy the fact that they can just go into that room and just relax for a while. So please fill it out. All right, let's see how we did on number 13. We're getting tired. Okay, so the question, and remember I said before with evidence, sometimes you got to really think about privileges. And they do love to test privileges, I will tell you that. And in this particular question, we're looking at the difference between the marital communications privilege and spousal immunity. Now, under the federal rules, both are recognized. Just make a little note, we're going to get to Florida evidence later. Florida recognizes marital communications, but Florida does not recognize spousal immunity. Make that note, because if you get Florida evidence, which you're likely to do in the multiple choice, that will be one question at least. So here, though, we're under the federal rules, and the statement, I really did know the equipment was stolen. The question is that statement admissible? Now, it's testimonial evidence. We're at that first question, what kind? But we're going to look at the privileges again. Just as an aside, though, remember I told you to think about what, be a little more specific about what it is. I really did know that they were hot. That's a, what word? It's a, yeah, it's an admission. I knew they were hot. It's an admission because it's being made by a party opponent, and it's clearly against his interest. But even though it's an admission, the question is it privileged? So, in this particular case, we've got a husband and wife, and the communication is made while they're sitting at, I guess it was the dining room table? They're sitting at home. We want to distinguish between marital communication and spousal immunity. Start with marital communication. The parties have to be married when? When the communication is made, right? It's got to be some kind of communication, and it has to be made when they're married and in confidence, right? Because if you're out with your spouse and you're sitting in a crowded restaurant at a table with 6 other people and you blurt something out, even though you're there with your spouse, is the marital communications privilege going to apply? No, because it wasn't made in confidence. It's got to be made at the time that they're married and in confidence. What about in this case? Yeah. So now the question becomes, who owns the marital communications privilege? Under the federal rules, both spouses. So can the husband, can the husband prevent the wife? Yes, he can under marital communications. But now let's consider spousal immunity. They have to be married when? At the time the spouse takes the stand, which they are here. But who owns spousal immunity? Witness spouse. So could the wife choose on her own to testify in respect to spousal immunity? Yes. But can the husband prevent her from testifying? Yes, under marital communications. And that,
So they can both apply in a criminal?
yes, got to be yes, criminal, correct. Yeah, I should have qualified that. Yeah.
Okay, because I thought that the spousal immunity, since it just applied in the criminal setting, then it excluded the marital communication privilege to apply as well
In what setting?
in the criminal setting.
No, oh no, marital communications applies in criminal.
It does.
Yeah, oh yes. Yeah. Okay, other question? Yes, ma'am. Yvette?
Which one is it that the husband
In terms of who owns it? Marital communications, both spouses. Spousal immunity, under the federal rules, the witness spouse. There was a common law had a different rule. But you don't need to really worry about that.
And which one of the two is the one that survives divorce?
Marital communications. Because it's as long as that communication is made while they're married. Okay, other questions on that? And as I say, we'll revisit it in the Florida context a little bit later. All right, number 14, last question. A. And once again, I would encourage you, by the way, go to the web course. You can get analytical answers for all these questions that explain in a lot of detail that I've written out. Oh, no. You just put your name on it.
Okay.
As long as your name's on it. Yeah, I'll walk around for anybody else who has not done the ticket. Yeah, we can go ahead and start. Josue, are you?
Oh, yes.
Okay. That's okay. I'm just being efficient. You done one?
Oh,
Yeah? Okay. Thanks, Simon. Andrea? Yeah. Thank you. Okay, let's see how we did. And on this last question, it's an easy question, but if you're sleeping, it's one that you'll miss. So let's see how we did. Interesting. A is the right answer. Now, can anybody tell me why A is the right answer? What's the call of the question? Attempted murder. And we know that all attempt is, fill in the blank. What kind of intent? Specific intent. Now, a couple of comments on criminal law. Number one, and depending a lot on who you had for criminal law, some of your professors may have focused primarily on the Model Penal Code. The bar exam tests almost exclusively the common law. Sometimes I'll give you statutes that look like Model Penal Code or some variation on the theme. But if there's no statute, you must apply the common law. So if you had a professor who focused on Model Penal Code, make sure you go back and learn common law. That's number one. Number two, in your criminal law class, you may well have not spent very much time on theft crimes, particularly if your professor focused on Model Penal Code, because all those picky differences that were present in the common law are not present under the Model Penal Code. Make sure, if you had a focus on Model Penal Code, that you go back and you look at all of the theft crimes. Larceny versus larceny by trick versus embezzlement versus false pretenses, because they love to test those picky differences. All right, so let's see how we did on this particular question. Oh, we did already. A. Okay, it's specific intent. A is the right answer. And if you look at the choices, B, yes, because victim did not die. Do we care if victim died? No, because it's attempt. That's the whole point of attempt. C, no, because he acted recklessly in throwing the firebomb. A number of you picked that one. Yes, he acted recklessly. Do we care? No, it's attempt. It's not murder. Nobody died. So specific intent. And D, no, because victim was injured. No, the whole point is there was no specific intent. Okay, last call on the tickets. All right, so usually the guest speaker, if we have a guest speaker or somebody else, picks, so then I don't get blamed. But let's see who we get here. You can see I'm mixing it up really good, right? Okay.
Yeah.
All right, who do I have here? Where's Paula? I saw Paula before. Oh, there's Paula. Yeah, Paula wins. Okay. Yes. Okay. Now, what you do is I take this upstairs, and then Sarah will be in touch with you. But what you have to have your name on the receipt. So and just as a kind of heads up, and by the way, you know, if you come, we have 3 classes this week. That's 3 chances to get a hotel room. And when we do the barbecue, which we'll do after FloridaCon Law, we do 2 drawings. So it's a small group. You guys have a good chance. But just be aware, if you're sharing the room with somebody, your name has to be on the receipt, because otherwise we can't, and we reimburse, obviously, and it's up to $300. You can't go to the Ritz and do the bridal suite, okay? You can, but we won't pay for the whole thing, right? So congratulations, we'll be in touch, and we'll see you on Friday. I will give you my predictions, such as they are, for the essays, and we'll start talking about essays. If you have a lunch order, bring it on up.